This is We the People News. That's pretty straightforward.
Oh, anyways, I talked to the sheriff dispatcher for a bit, and he gave me an email address. Said, send your information here. This is the incident report, and the emergency management dispatcher isn't here today, but I'll get it to him for tomorrow. So I did, and so this is what I told him. Political disenfranchisement and other crimes against the United States. Emergency Management Homeland Security Incident Report 22, 141, 128. Now, of course, he didn't say that's what it was, but I'm saying that's what it is. Right, I want to make perfectly clear, it has nothing to do with local jurisdiction. Right, this is a national issue. So, something I want to show is this is out of the state constitution for Michigan under local government section, where it talks about sheriff, right, security responsibility for acts. Right, so the sheriff may be required by law to renew his security periodically, and in default of giving such security, his office shall be vacant. The county shall never be responsible for his act, except the Board of Supervisors, which is now the county commissioners, may protect him against claims by prisoners for unintentional injuries received while in his custody. He shall not hold any other office except civil defense. And so as it turns out, what we call today emergency management is originally the civil defense system that was set up after World War II, worried about nuclear bombs, all that kind of shit. And it's a national jurisdiction. So when the sheriff puts that hat on, he's working for a different, or in a different jurisdiction than when he's acting as the county sheriff. And this has nothing to do with that, but as we're here, so we have this thing here called the Board of Supervisors. And this is still in the Constitution today. Right, that the Board of Supervisors shall be established for each organized county, consisting of one member for each organized.
That is actually the beginning process when they stole the sheriff from the people. By the way, y'all. Just saying.
Township and such representation from cities as provided by law. Well, we don't do that anymore. Right now we have county commissioners, and this, little footnote here says constitutionality. Section, right, Section 7, held invalid under federal constitution. Well, that would make the Michigan Constitution unconstitutional. If one part's wrong, the whole thing is wrong. They've never changed it, and they have some reason for not changing it, but apparently that's not the way she works anymore, that now it's these county commissioners with the county acting as a local government instead of the townships acting as a local government. So, been quite a web they've weaved over time. But anyways, this is what I had to say to the deputy, right? So, deputy, thank you for your service and taking my call. I'm a U.S. Army veteran bound by oath to protect and defend the Constitution of the United States. And Incident Report 22, 141, 128 is my express will to fulfill my obligation, not to fulfill my obligation. FYI, for your information, all veterans are still in the United States military, as we have not received our administrative discharge order, releasing us from custody and control of our branch.
So, I'll wax about it too. What he's saying in short is, even though that you've been released to duty and you get to go home and all that kind of stuff, they never, ever follow the correct documents for the veterans. So really, when we say veterans, they're still inactive, so they're not actually still veterans. And that enhances probably the reason why all these, they're not getting their full benefits. Okay? It's because they're still considered a trickery of words active members, okay, due to not following the right paperwork to make the veterans be veterans. So, check out, for you veterans out there, check out some more of his stuff, earlier videos about how this actually to be what's going on with you veterans, and learn the trickery that the United States is suckering our veterans. Makes me mad.
Sending you a few attachments that include the statement I read 911. Check that, and various proofs to establish probable cause of crimes against the United States. This is a national civil defense emergency out of the jurisdiction of an alleged county prosecutor. For the sake of clarity, I'm pasting a few sections of the Constitution of the United States referenced in the 911 statement to this email, which are, basically these. In Article 4, Section 4 says the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and an application of the legislature or executive against domestic violence. Well, we've been invaded, right, by esquires. Esquires are a crown agent by definition. Right? Article 6, Sections 2 and 3. So the Constitution and laws of the United States shall be made pursuant thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and judges in every state shall be bound thereby, and anything in the Constitution or laws of the state to the contrary notwithstanding. So, right, the Constitution is the supreme law of the land, and in Avery versus Midland County, the Supreme Court interpreted the Constitution to say that for equal protection of the law under the 4th and 14th Amendment to be valid, that we had to have equally proportioned election districts for the person that's going to represent us at the local level. And that isn't the way it was under townships, but that is the way it is under county commissioners. So the second part is that the senators and representatives before mentioned and members of several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification in any office or public trust under the United States. Now let me walk you through the probable cause of crimes against the United States. As is plainly written in Article 6, state legislatures, executive judicial officers of the state must execute an oath to support the Constitution of the United States. What it does not get talked about is that the very first act of Congress after ratification of the Constitution, signed into law by President Washington, mandates the form of oath and its recorded requirements. See 1 Stat 23. It's attached. And is also codified in United States Code as 4 USC 101/102, also attached. So real quickly then, in the laws of the United States, right, Acts of the First Congress of the United States says that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following to wit. I state your name, you solemnly swear or affirm, as the case may be, which is in there, that I will support the Constitution of the United States. Right? There's no so help me God, there's no other stuff. Just I, your full legal name, you solemnly swear or affirm that I will support the Constitution of the United States. Well, that isn't the oath they're taking. Right? So now the Constitution says, well, Article 6 is for state officers and officers of the United States. But they went further then, and they said, well, now we're going to put it in the U.S. Code, and we're going to say in Title 4, United States Code, Section 101, that every member of the state legislature and every executive and judicial officer of a state shall, before he proceeds to execute duties of...
Now, I had to be honest with y'all. Past videos, I've gotten Article 6 and Article 4 backwards, okay? So the Article 6 is the original, and Article 4 that's been codified, okay? I kept on saying Article 6, USC Title 4, Section 101, okay? Apparently it's Article 4, Section 101. So my apologies for all the other videos I misled people. But not innocent. I do things wrong sometimes. Always investigate for yourself.
His office, take an oath in the following form. Right? There's the same oath. And then such oath may be administered by any person who, by law of the state, is authorized to administer the oath of office. And the person so administering such oath shall cause a record or certificate thereof to be made in the same manner as by law of the state he is directed to record or certify the oath of office. Right? So until they have that, they don't have any authority. And that's where we stand today. They're not executing this oath. They're not recording this oath. And so they're not who they say they are. So then this mandate supersedes all other requirements for qualifying for the public office in Michigan. And federal law requires the incumbent have proof by record or certificate. If this oath is avoided by someone claiming to be a public officer, then that individual is an enemy of the United States, warring with the Constitution of the United States. Ignorance of the law is no excuse. And because we're talking about the Constitution and everybody has their opinion, some people tell you there's 3 constitutions. Some people say there's a Constitution of 1871, there's a Constitution of 1776. This is the Constitution I'm talking about, the one in the 108th Congress, right, which says on it that it's the Constitution of the United States. Right? It's commonly called the Pocket Constitution, which you can Google Pocket Constitution, and there it is, Pocket Constitution. This is where it came from. Right, on govinfo.com or .org, .gov. Right, this is the one I'm talking about. Okay, just so we clear that up. Okay, so Gretchen Esther Whitmer is one such enemy of the United States. Not only did she avoid, or she didn't do it, executing the national loyalty oath, but she also counterfeited the oath required by the Constitution of Michigan of 1963. I have attached her counterfeit state oath I received when I submitted a FOIA, Freedom of Information request, to the Michigan Secretary of State, asking for all oaths filed by Whitmer. The national loyalty oath was not returned as part of the FOIA, and on the oath she submitted are the following invalidating indicators. The grammar of the oath text has been altered. Whitmer used an alias to conceal her full legal name, identification on the loyalty oath. A notary is unqualified by state law to administer an oath to the governor. And she is using a counterfeit of Michigan's Great Seal, upon which "the" is not part of the seal wording, nor is the capitalization used. MCL's 2.42.
Every state's doing this, by the way, y'all.
So here's what the Great Seal Act says in Michigan, right? The Great Seal shall be comprised, coat of arms, state around which shall appear the words Great Seal of the State of Michigan, right? All letters are, or all words are lowercase except for Michigan. But when we look at what she did, what she does, all right, here's the seal that's being used, where the word "the" has been added, and it's all in uppercase. Well, then this is a counterfeit. It's really that simple. And, in this particular case, this is the document that shut down Michigan for 2 years, right? For Executive Order 2020-4, Declaration of State of Emergency. And then just real quick, if you look at the FOIA I did to get her information, right? Written request for image of the oaths of office subscribed by Gretchen Whitmer for the office of governor of the state of Michigan and its commander-in-chief. Right? Hey, we'll answer your question. And they sent me this. This is supposed to be oath of office, right? That, they changed the style of the words, right? Because the Constitution of the state should all be lowercase. So the, grammatical change changed the meaning of the sentences. So it's not the same form, right? And Whitmer didn't use her full legal name, right? So she used an alias on a loyalty oath, which means it's invalid. And then it was, done before a notary public by Michigan Compiled Law 1536, 1537. I believe it's actually 1537, where it says who can give the governor an oath, and one of those people listed is not a notary public, which is who did it. Right? So this isn't an oath to satisfy the Constitution. It's a counterfeit to simulate satisfying the Constitution. Okay, continuing on. There's now a vacancy in the office of governor for failure to subscribe a constitutional oath. MCL, that'd be Michigan Compiled Law 168.66, which is out of the election code. Governor or lieutenant governor vacancy, creation, impeachment. Right? The office of governor or lieutenant governor shall become vacant upon the happening of any of the following events: death of the incumbent, his resignation, his removal from office for cause, his ceasing to be a resident of the state, his conviction of an infamous crime, or an offense involving the violation of his oath of office, the decision of a competent tribunal declaring his election void, or his neglect or refusal to take and subscribe to the constitutional oath of office and deposit the same in the manner and with the times prescribed by law. Didn't happen. Office is vacant. Deputy, Michigan election law makes it your duty to initiate criminal proceedings. This is also out of the Michigan election law. I'm talking about peace officers' duty to investigate proceedings. It's hereby made the duty of any police, sheriff, or other peace officer present and having knowledge of any violation of any of the provisions of this act to forthwith institute criminal proceedings for the punishment of such officer. I don't know what to tell you. Better be filling out the paperwork. It is not just Whitmer. No county officer, including the sheriff, has complied with the law to be a public officer they claim to be. No judge,
There you go, Michigan cop watchers and auditors. There you go.
justice, county commissioner, prosecutor, senator, representative, and is qualified incumbent of a public office. And this is why this is a national emergency. Michigan election law, again, MCL 168-191, county officers eligibility requires all county candidates to be registered qualified electors of the county in which the election is sought. Why, sure enough, Michigan election law, a person is not eligible for the office of county clerk, county treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, surveyor, or coroner if the person is not a registered and qualified elector of the county in which election is sought by the filing deadline. Right? And to be a registered, qualified elector of anything in Michigan requires you to take an elector's application that has an affidavit on it to the registration clerk so they can swear you to your statements. And nobody does that. Well, like I said, you can vote when you go and get your driver's license. Well, hey, here we go. Take notice. An elector registration is not a voter registration. According to MCL 168-499, in order to register as a qualified elector requires executing an elector registration application. That contains an affidavit and appearing before the registration clerk to have the affidavit oath administered by the registration.
Now remember, y'all, for being to vote for the president, the electors, right? And we've been duped into them two trickery of words: election and electors. We've been duped.
And the application recorded. There is no such requirement for voter registration. And again, to the Michigan election law, where an elector entitled to registration in an election precinct may become registered in the precinct by applying in person and signing the registration application before the clerk or assistant clerk of the township, city, or village in which the precinct is located. For the performance of his or her duties under this act, each clerk and assistant clerk has the power to administer oaths and to swear persons as to the truth of their statement contained in the application. Nobody does that. Right? And this isn't something you do at the township, because the election precinct that I reside in now, because of Avery versus Midland County, is actually the commissioner's district. In my case, it's the 4th commissioner's district, Kent County. With Kent County acting as a city or a municipality instead of as a subdivision of the state. So if you investigated to determine that the county officers of 168-191 swore to the contents of an elector registration application, you will soon determine that they have not. This would include the county clerk, county treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, surveyor, coroner. We have the same defect. It is part of the scheme run by Esquires to ensure that no inhabitant of the county is registered as a qualified elector of their county election precinct. I am sure you have never swore a registration application, and neither have I. This is intentional political disenfranchisement, crime against the United States, and we the people. The federal government has a duty under 1965 Civil Rights Act to ensure we electors are properly registered, and the Supreme Court of the United States interpretation of the Constitution of the United States in its Avery versus Midland County decision requires the county commission districts are also our local government election precinct. Until I'm a registered qualified elector of my county election precinct, I am the victim of an ongoing crime against the United States of political disenfranchisement. Respectfully submitted, blah, 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 blah. Okay, and so, well, what can be done? Well, one thing is, under the Emergency Management Act of the state, right, so every state's got an Emergency Management Act, I'm sure, right? It has certain things that the county can do. And in our case, in Michigan, it's under Section 410, powers of county and municipality. Right, each county or municipality has appointed an emergency management coordinator. Under Section 9, may do one of the following, or one or more of the following. Right, so as long as you're talking to the emergency management, that has a coordinator, then these apply. And one of them is, right, declare a local state of emergency. If circumstances within the county or municipality indicate that the occurrence of threat or widespread or severe damage, injury, or loss of life, property from natural or human-made causes exist, and under a declaration of this local state of emergency, issue directives and travel restrictions on county roads. This power shall be vested in the chief executive official of the county or municipality, or the official designated by charter, and shall not be continued or renewed for a period in excess of 7 days, except with the consent of the governing body of the county or municipality. The declaration of a local state of emergency shall be promptly filed with the Emergency Management Division of the department under circumstances attended upon the disaster, prevent or impede its proper filing, or unless circumstances. Okay, so there you go. So if I could get them to do this, just go ahead and issue a local state of emergency, because there's nobody, in the civilian government that can issue an oath of office, because there is no civilian government. But the military can. And under Michigan law, there's people in the military that can issue an oath of office. Because military officers are not covered by the 6th Article of the Constitution. They're not an executive or judicial officer. They're a military officer. Now, up until they created the DOD, they were executive officers. But when they created the DOD, they said, hey, military officers are no longer executive officers. That falls on the head of the DOD, secretary of the DOD. And so they're military officers. And these military officers and enlisted, we take a different oath than is required by the 6th Article. So there's nothing wrong with our oath. We're oath-bound protectors of the United States. And so emergency management, come on in, bring in, some military officers that can issue execute some oaths of office, and that's how you get everybody in their proper office, get registered. But unless we declare it an emergency, they're going to, keep hiding it. But if it was declared an emergency, well, that would make it a national emergency. And I'm all about this being a national issue. It's not a local issue. And the only reason I'm going to the sheriff is because the sheriff wears 2 hats, right? He can be a member of the civil defense, which is a national jurisdiction. Okay, I'm going to leave.
All right, there you go, y'all. I don't know. You guys decide. Something's going wrong. Remember what people say. Keep doing the same thing over and over and over, expecting a different result, is insane. So, you know, if you want to keep it doing the exact same thing, then you're insane, and you may have to see a psychiatrist. And it sounds like to me that, you know, the whole government officials may need to see a psychiatrist. Take a leave of Athens. All right, this is We the People News. Bye, y'all.